Well, we have brought you team coverage on the pretrial hearings of the Freddie Gray case. And the next hearing is scheduled for September 10th, as Brian mentioned. That's where the change of venue will be requested. So we're going to go in depth on the details of today's hearing with attorney Warren Alperstein. Thank you so much for coming in.
My pleasure. Good to be here.
So you said that was a bombshell. The fact that there's 6 separate trials.
It really was. It was unexpected. I was in the courtroom, and I don't think anybody expected that decision to be made today by Judge Williams.
Now, how does that affect the state's case?
Well, it affects it in a number of ways. It's always keep in mind the state wanted to join certain defendants, officers together in the case. And the reason why they do that is it allows them to strategize certain ways to make their case better. They opposed any motion to sever or split up the defendants as the defense attorneys wanted to do. So that being said, there are now 6 different trials. And whenever you have 6 different trials, or multiple trials for that matter, between co-defendants, there are a number of challenges. The first of which is the state's in a position now that they have to decide which defendant's going to go first.
Right.
And that's a real challenge. Do you try one of the officers like Miller or Nero, who are simply charged with misdemeanors, that being second-degree assaults? Right. Or do you try the Officer Goodson, who is at the top of the chain, if you will, who's charged, as you know, with second-degree murder? Or do you try one of the officers in the middle, if you will, that are charged with the manslaughter?
And then you got all the witnesses who are going to have to be prepped.
It's exactly right. So one of the other challenges the state, will have to endure is that every time a witness testifies in a trial, they are subjected to impeachment. That is, are they making an inconsistent statement? So every statement that they make at a trial will be compared to any statement that they previously made, be it at a previous trial or
interviews.
Exactly. And so as you get further down the road and through different trials, again, every statement that a state's witness will make can then be examined by the defense attorney to say, hey, is there something different they're saying now than they said before at one of the earlier trials?
And then you got to think about a change of venue as well. Brian touched on that as well. Are all the trials going to be here, and then you're going to have to worry about having a tainted jury pool?
That's exactly right. So there's always, of course, the scenario that whoever gets tried first is acquitted. So as we saw, now we already have some protesting today. If the first one gets acquitted, do we have civil unrest? Do we have just protesting, or do we have rioting? If you have rioting, how does that affect the jury pool, the citizens, if it stays in Baltimore City, who are potential future jurors? Can they maintain a fair and impartiality in the subsequent trials? And certainly any civil unrest absolutely would affect that.
What can you tell us about the judge? I heard he was a no-nonsense kind of judge.
Judge Williams is an independent thinker. He's bold. He's the perfect choice. That's why he was appointed by the administrative judge in Baltimore City to preside over this case. So on the one hand, it was unexpected, but it's not unexpected that Judge Williams would make a decision that would be, somewhat surprising, because he, at the end of the day, has to balance 2 things. One is the court's interest in judicial economy, which is the idea of moving things along, conserving resources. So balancing that need versus the absolute need to ensure that defendants receive a fair trial. And he found, unequivocally that, hey, it's the defendant's, need for a fair trial overrides any other interest.
I think we'll be seeing this guy in here next week.
My pleasure.
Thanks a lot for coming in.
Thank you. My pleasure.
Well, stay tuned.